Thank you, Matthew. Hello, everybody. I would like to touch on what I perceive as 10 unresolved issues in New Zealand charities law at the moment. And I think if there's an underlying theme, partly it would be unintended consequences of statutory changes that were made. And it would also be what I'm calling a clash of paradigms. And in my view, these underlying themes permeate through the 10 questions or unresolved issues. The first is, as Matthew has been alluding to, what is the test for determining what what an entity's purposes are? So, and Matthew outlined the orthodox approach, that it's basically a matter of interpretation of the constituting document. And in that sense, it's the same process as interpreting a contract or interpreting a statute. The ability to look to extrinsic material is limited. But the problem in New Zealand, I think, comes down to Section 18.3 of the Charities Act, which says in determining an application for registration, charity services is to have regard to the activities. And Section 50 says something similar for existing charities. And I think we're, unfortunately, Section 18.3 does not say what charity services is to have regard to activities for. There are no criteria in the Charities Act, and in particular, nowhere in the Charities Act does it say that activities must be charitable. So the problem seems to have crystallised in 2004 when the Supreme Court said at paragraph 14, purposes may be expressed in the statement of objects or inferred from the activities, as Section 18.3 makes clear. So to the extent that those statements of the Supreme Court might have created doubt, I would argue that the uncertainty was helpfully clarified by Justice Ellis in 2016 in the Foundation for Anti-Aging Research case at paragraphs 82 to 88. And Her Honour goes through the pre-existing case law and basically what is the orthodox approach, what I'm calling the Latimer paradigm, that there is an extrinsic evidence rule. It should be as rare to infer a purpose from a charity's activities as it would be to put the terms of a contract to one side as a sham. The role is of the court and of the decision maker is interpretation, not creation. So I would argue that the position should have been considered settled after the High Court decision in Foundation for Anti-Aging Research. But following the decision, there was, from what I can see, no discernible change in approach. And one question that arises in this context is, if we're going to infer purposes from a charity's activities seemingly without reference to the constituting document, how does that sit with the duty of officers of a charitable entity to comply with the terms of their constituting document? This has never been explained. Sections 24 and 26 of the Trusts Act, Clause 50 of the Exposure Draft Incorporated Societies Bill, and Section 134 of the Companies Act 1993 all make it very clear that governors of charities have a duty to comply with the constituting document. So what causes difficulty in practice is that a charity might be in good faith working in its assiduously in furtherance of its stated charitable purposes, but there will always be this risk that it will be told by charity services that, no, actually you have another purpose that's not stated, and we think that purpose is not charitable and not ancillary, and therefore we are deregistering you. And I think an example of that was in the Greenpeace board decision, where the decision was made that Greenpeace had an illegal purpose. And I think it must be quite extraordinary for a charity to be told that it has an illegal purpose that it doesn't think it has. I mean, fortunately, this position was corrected on appeal, but it is a problem in New Zealand that it's very difficult to appeal cases under the framework as it's currently structured. So a key unresolved issue in my view is, what is the test to be applied in determining what an entity's purposes are, and what is the relevance of activities in that context, and the status of the extrinsic evidence rule. And I think it's actually, there are parallels with tax law in this context, because one of the big issues in tax law is whether you can take a substance over form approach. And it's interesting to note that the Court of Appeal in the Latter-day Saints case, in the context of donations to charities, confirmed that people are entitled to be taxed on the basis of the legal arrangements that they have actually entered into, not on the basis of their underlying substance. The Commissioner of Inland Revenue sought to appeal that decision, and we just heard yesterday that the Supreme Court has declined leave to appeal that decision. So that decision stands. That it basically comes down to the wording of the document and the arrangements that you have actually entered into. So that leads to the second unresolved issue, in my view. Having determined what an entity's purposes are, what is the test for determining whether that purpose is charitable? The Court of Appeal in Latimer in 2002 held that it was common ground that there was a two-step test. Step one, is the purpose for the public benefit? And step two, if it is that purpose charitable in the sense of falling within the spirit and intent of the preamble to the Statute of Elizabeth? The Supreme Court in Greenpeace affirmed Latimer, and it did not dispense with this test. In fact, despite at times using a shorthand expression that might appear to conflate the two limbs of the test, the Supreme Court was at pains to emphasise that both limbs of the test must be satisfied. And importantly, that test applies to purposes. It doesn't apply to activities, and it doesn't apply to the organisation itself. Now, with respect to that first test, the question of whether a purpose operates for the public benefit is a question of fact to be determined on the evidence. And as Matthew said, it brings in detriments, balance benefits and detriments. And I think it's impossible to overstate the significance of the fact that New Zealand charities have had their ability to access a trier of fact inadvertently removed as a consequence of changes hastily made at a select committee stage in 2004. Prior to the Charities Act, charities were able to access a full de novo hearing of evidence before a trier of fact. And for an example of that, a very good example of that, I would refer to the High Court decision in Latimer and followed by the Court of Appeal decision. And under the current framework, I very much doubt that the purpose in that case would have been found to be charitable, because the charity just would not have been able to establish the evidential platform that was necessary. So I think reinstating access to a trier of fact is one of the most important issues that needs to be fixed by the review of the Charities Act, in my view. And this would have a number of important side effects. For example, it would allow the decision maker, whether it be Charity Services or the Charities Registration Board or the Charities Commission or whatever agency ends up administering the Charities Act, to appear adversarially in support of its decision and to appeal a decision it doesn't agree with, as is currently the case with IRD. So it would fix problems at their source without the intervention of the Attorney General. So with respect to the second step, the first, whether a purpose falls within the spirit and intent of the Statute of Elizabeth, the first three heads of charity are presumed to fall within that spirit and intent. But for purposes under the fourth head, the spirit and intent may be established by analogy with purposes enumerated in the preamble, or by analogy with previous cases found to be within the spirit and intent. Now, that analogy upon analogy approach tends to expand the concept of charitable purpose over time. In fact, by 1968, the House of Lords in the Scottish Burial Reform case said that the gradual extension by analogy had proceeded so far that there are now few modern reported cases where a clearly specified object for the benefit of the public at large and not of individuals was not held to be within the spirit and intent of the preamble. And by 1975, New Zealand law had extended so that there were two approaches to determining whether a purpose fell within the spirit and intent of the preamble. The first was the analogy approach, and the second was the presumption of charitability. The presumption of charitability says, even in the absence of an analogy, purposes that are beneficial to the public are prima facie within the spirit and intent of the preamble in the absence of any ground for holding otherwise. The Court of Appeal decision in Morgan and the Wellington City Council, 1975, 1 NZLR 416, is an example of that. And in fact, IRD in its 2001 Tax and Charities discussion document refers to it as well at paragraph 3.17. So it was firmly part of New Zealand law prior to the Charities Act. It's important to note that the presumption of charitability does not dispense with the second limb of the test. It's another way of answering it. And as the Supreme Court notes, it doesn't really come up with a particularly different result, because after 4 centuries, there are so many analogies that it isn't hard to find one. But as noted by Justice Hammond in the Collier deceased case in 1998, it's more intellectually honest, because the analogy approach can throw up some anomalous results. For example, in the Vancouver Regional Freenet case, the access to the internet was found to be charitable on the basis of analogy to the repair of highways in the preamble. So I think that's what Justice Hammond was meaning by it being more intellectually honest. I mean, isn't it better to say that that's beneficial to the public and there's no apparent reason why it shouldn't be considered to be within the spirit and intent? Now, it's important to note that the presumption of charitability had been specifically rejected in Canada, in contrast to New Zealand, where it was specifically part of our law. And the Supreme Court in Greenpeace appears to have conceptualised the presumption of charitability as a single test of public benefit. And that was the argument put forward for the Vancouver Society of Immigrant and Invisible Women in the Supreme Court of Canada case that goes by that name. But that, with respect, is a different concept to the presumption of charity. A single test of public benefit is not the presumption of charity. It doesn't dispense with the second limb of the test. It seeks to find it. So with respect, I respectfully suggest that the Supreme Court appears to have misdirected themselves in that regard, and a key unresolved issue in New Zealand relates to the status of the presumption of charitability. And this is important in practice because it simply means, if you're in doubt, err on the side of charity. And if we take too narrow an approach to determining whether a purpose is charitable, we end up with significant administrative difficulties when that approach is ultimately corrected, as has recently been the case by the High Court decision in Greenpeace. And I understand that Charity Services is currently in the process of contacting about 450 charities following the decision of the High Court in Greenpeace. But those are only the ones that Charity Services knows about. There will be many other charities that will not have applied for registration or will have withdrawn their application or who will have limited their advocacy for fear of losing their charitable registration. Charity Services mentioned the recent decisions in their August 2020 newsletter, but I don't think, with respect, that the wording sent a clear message to those charities that would speak to them clearly that they maybe should try again because their eligibility for registration should be considered under a different test. I also would like to see Charity Services work with the charitable sector and the profession to develop its revised approach. In my view, it would be in all of our interests to come up with an agreed interpretation, if for no other reason that it would save all this litigation. So, Kate, just stop me if I'm taking too long because I may not get to all of them. I'll just do my best, but I'll stop when time's up. So the third question is, has the two-step test been conflated into a one-step test? And this Charity Services consistently states that a purpose is charitable if it advances a public benefit in a way that is analogous to cases that have previously been held to be charitable. But with respect, the benefit does not need to be analogous. It needs to be established on the evidence, weighing benefits and detriments, underscoring the importance of access to a trier of fact. There is no requirement for the public benefit to be analogous to anything. It is the purpose that must be analogous, not the benefit. As discussed, the Supreme Court at times used a shorthand expression that might have appeared to conflate the two limbs of the test. But the Supreme Court was in fact at pains to emphasise that both limbs of the test must be satisfied. If the Supreme Court was intending to make such a radical change, it is reasonable to expect that it would have said so. But to the contrary, the Supreme Court specifically said that it was not making any radical change. So one of the key issues that needs to be resolved, in my view, is what is the test to be applied in determining whether a purpose is charitable. The fourth question is, what is the relevance of activities in that regard? It's important to note that advocacy is an activity. It is not inherently a purpose. Justice Ellis in the Foundation for Anti-Aging Research case at paragraphs 87 to 89 clarified that the question with respect to activities is whether they are carried out in furtherance of the charity's stated charitable purposes. If they are, there is no difficulty. And I think this is where the rubber really does meet the road in New Zealand, because I think what's happened is that the distinction between purposes and activities is being conflated, and this is causing us to swing between two paradigms, the Latimer paradigm and what I'm calling the alternative paradigm, that is causing our law to become incoherent. Because if you look at the Foundation for Anti-Aging Research case that was decided in 2016, and then you look at the two next cases, which is the High Court decision in the second High Court decision in Family First and the High Court decision in Better Public Media Trust, it's as if they're from different jurisdictions. And interestingly, both those two cases are subject to appeal either before the Court of Appeal. So I think that's another key issue that we need to resolve, is what is the relevance of activities and what is the distinction between purposes and activities. And that flows into the fifth question. Advocacy is an activity.
Sorry to interrupt. Do you think you could get through your last 5 questions in about 7 or 8 minutes to give time for some questions? I don't want to stop you, but that would be great. Thank you.
Thank you. Yeah, I'll speed up, but just stop me when I need to stop. Thank you. So the fifth question, in the very rare circumstance when advocacy might have become a purpose in itself. Now, bear in mind that advocacy is an activity, so it's rare for it to actually be elevated to a purpose. But if that is the case, the Supreme Court said it is not precluded from being charitable. It will basically depend on the facts. I would argue that that was always the law, and that the Supreme Court did not change the law in this respect. And in that regard, I would refer to the Court of Appeal decision in Latimer. I'd be very happy to talk about that in more detail. I think Malloy is right on its facts, but ultimately whether a purpose is political is a question of fact. It comes down to the public benefit test. Malloy did not translate into a hard and fast rule that we had some strict political purpose exclusion in New Zealand law. That cannot be the case, because the Court of Appeal in Latimer confidently found the assistance purpose in that case to be charitable, despite the fact that the treaty process was highly controversial at the time and always ended without exception in an act of Parliament to settle the wrongs. So clearly a political purpose could be charitable. It comes down to the facts, I would argue. But it's important to note that before the ancillary test can be applied, there must first be a purpose. Section 5.3 applies to purposes, not activities. So one of the key unresolved issues is to clarify that the ancillary test applies to purposes, not activities. Is there a separate test for advocacy? In this regard, the Supreme Court decision, in my view, is open to more than one interpretation. The concept of ends, means and manner, the Supreme Court does not analyse how that sits with the comments of the Privy Council in Latimer at paragraph 36, but the relevant considerations are ends, means and consequences. I would argue that the ends, means and manner terminology relates to the unique multi-layered abstract purpose that was at issue in the Greenpeace case, the promotion of peace through the promotion of nuclear disarmament and the elimination of weapons of mass destruction. it seems unlikely that the Supreme Court was intending to usher in a fundamental overhaul of the test for whether a purpose is charitable. And as the High Court noted in the Foundation for Anti-Aging Research case at 86, it seems unlikely the Supreme Court was intending to reach some fundamental change in approach or a move away from the fundamental purposes nature of the inquiry. And importantly, I would argue it's not to require means and manner to be charitable or to require a charity to show public benefit in all of its activities, because that would put us out of alignment with the rest of the common law world. I did want to speak about advancement of causes, but I'll leave that. And just very quickly to the relevance of the international context, I think it's relevant in a number of ways, but two in particular. The New Zealand Law Commission, in its review of trusts in 2013, made the point that departure from internationally accepted trust law principles should occur only where it's justifiable based on the New Zealand context and then only with caution. Is there something different about New Zealand that demands a departure from the principle that it's the trust law principle that its purposes must be charitable, not activities? This is important because charities are operating increasingly internationally. Is it helpful to have a unique set of idiosyncratic rules just for New Zealand in this context? But more importantly, New Zealand is a signatory to a number of international treaties, such as the Covenant on Civil and Political Rights and the Universal Declaration on Human Rights. The High Court decision of Wall and Fairfax has clarified that there is a presumption of statutory interpretation that so far as the wording allows, legislation should be read consistently with New Zealand's international obligations. The right to freedom of expression is one of the most essential elements of a democratic society, and while the right can be restricted, the circumstances in which this is permissible are strictly limited. Restrictions must conform to strict tests of necessity and proportionality, and the burden of justifying a limitation lies with the state. So my question is, in this approach, which is very subjective, very complex, and some would argue quite arbitrary, is it consistent with our international obligations? And has Charity Services discharged its onus of demonstrating how its approach is consistent with those obligations? So I also wanted to talk about fiscal consequences and wider public benefits. Matthew has touched on wider public benefits. So I just skipped to the last question, which is what I think, perhaps it's not an unresolved issue, but I think it is an issue that we need to look at. How can we infuse tikanga principles into New Zealand charities law? And also I would add the principles of the Treaty of Waitangi. I've always thought that the principles of the Treaty of Waitangi should be a mandatory relevant consideration in considering whether a purpose is charitable. And I do wonder whether we do need to actually clarify that by statute. But in the context of tikanga principles, I'd refer to the comments of Justice Joe Williams, who said in a recent article in the Dominion Post, the challenge is to integrate, to synthesize, to weave the best of both of these systems into something that is bigger and better than each individually. And wouldn't that be great if we could do that in New Zealand?